because I lived for many years, my entire experience in Muslim contexts as a Muslim was abroad. And when I came back to Britain, it was seeing sort of the Muslim community in a very different light. In fact, seeing it from the outside. And as Osama has mentioned, I worked for a number of years with women living under Muslim laws. And I'm also very now closely connected with the Muslim Women's Network UK, which is an autonomous women's group here. The experiences that I'd like to share with you are those experiences from abroad, in a sense, because I'd like to share the experiences of how Muslim laws operate in other contexts, but also then make a call for celebrating this public debate that has opened up, but at the same time demanding that there be the voice for women in that public debate, particularly if we recognise the fact that the vast majority of people who approach the Sharia councils on questions of family laws are women, and I think it's therefore very essential that we include women in that debate. Just very briefly, Muslim family laws have been an area of obsession for me since the 1990s, and I've written a number of books both on the theory of Muslim laws as well as, much more importantly, on the practice. This was arising out of a 10-year research project on family laws in different Muslim contexts, both majority, minority, and contexts where Muslim family laws are applied at the referenced with two religions, so they're based on interpretations of the Quran, as well as contexts, for example, such as Turkey, where the laws are so-called secular. So my understanding and explanations will come from that experience and that work. And my first question really is to ask why, as the way that things currently work in Britain and in the Sharia councils and the way women experience Muslim family laws in the Muslim community here, why we're prepared to accept a situation where Muslim women in Britain have fewer rights than are granted to Muslim women in other Muslim contexts. So this for me was a very great surprise when I came to Britain, having been married under Muslim laws in Pakistan, to find the very low level of rights recognised in the Muslim community in Britain. And I found this very difficult to understand why, because you have an image of Britain as a developed country, more advanced, more educated, etc., etc., and yet I found the levels of rights of women in the Muslim community here far less than the rights of women in Pakistan, for example. And one of the areas that I found most interesting was this whole business of divorce. In Muslim contexts, there are many, many forms of divorce which are recognised and which are intrinsically a woman's right to divorce. So this myth that khulla is the only form of divorce available to women, I find very surprising. It's certainly not the case in many, many other Muslim contexts, including, for example, in Pakistan. Also interestingly is that although it seems that the interpretation in the Sharia councils, of some of them that have been publicised here in Britain, that khulla is something that the woman has to ask from the man, is certainly not the way the law operates, for example, in Algeria, in Egypt, in Pakistan, in Bangladesh, in Nigeria. Those are the ones I can immediately think of. So in those countries, the Muslim family laws, they are framed with reference to Islam. The husband's permission is irrelevant, completely and utterly irrelevant. And again, so we can say that this may be, you may not agree with me, which is fine. This is an interpretation. But if we say that Muslim laws are diverse, and if we say that this is all open to interpretation, then we have to start recognizing that our lives as Muslims is something that is part of being a social being. This is part of society and part of politics. In other words, the whole question of interpretation is a social and political one. And if we recognize it as a social and political question, then we have to say we have to start debating these issues. I'm all for a very open and public debate on the role of religion in public life. And I think it would be a gross oversimplification to say that Britain is a secular society. I'm sorry, English marriage law is based on a very Christian concept of marriage. And that's one of the problems that exists in vis-a-vis the way it deals with Muslims. So I think we need to understand that this is a public role for religion, but if it's public and if it's going to be part of society, then we need to debate it, and we need to have women's voices in that debate. Now I'm just going to come to a little bit of the area of confusion. One of the problems in examining this whole question of the role of the Sharia councils is the lack of clarity over who actually needs to go before the Sharia councils and which laws govern whom. For example, there's a misunderstanding, a myth, that if you're married through a nikah in Pakistan or Bangladesh, for example, that is not a marriage recognized under English law. It is. It's a completely valid marriage under English law. And the way to go about unraveling that marriage, you can either do it here, through the British system, or, under certain circumstances, you can do it in the country where you got married. There are so many complications. One of the complications being that Pakistani law, and I'm talking about Pakistani law because that's the majority of the Muslim community here, and Bangladeshi law, which is exactly the same law, by the way, Muslim Family Laws Ordinance 1961. That law is a transnational law. It applies to Pakistanis and Bangladeshis no matter where they are, which is a complication, particularly in the case of people who are second generation or third generation Pakistanis or Bangladeshis, because in fact, technically that law could apply to them. Most people here don't know that. Most people here don't realize that there are certain provisions which could apply to them. So there are all sorts of complex situations. I'm not going to go into the different possible situations, but what we have is often a situation where people go to the Sharia councils and there isn't an understanding that in fact those people are governed by statutory laws. And if they are governed by statutory laws, whether it's Pakistani statutory law or British statutory law, they need to also take certain steps which match that statutory law. As I say, I'm not going to go into all of the complications of this, but I want to give some illustrations of the questions of having a parallel legal system, or having parallel laws, and the impact on women. Now, we've heard a lot of the word choice this evening, and that's very essential that people do have a democratic right to choose. But we must also look at the social circumstances of choice. And in fact, this whole question arose in Canada. I'm sure some of you are familiar with the fact that in Canada there was an attempt to introduce recognition for decisions by Sharia councils. And it was interesting to see that women from within the Muslim community who identified as Muslims, believing Muslim women, very strongly argued against legal recognition of these councils and their decisions, because they said that the choice, in fact, for women was not a free choice. If women see that they have different rights or a better form of rights available in one system or another system, they may not necessarily be free to choose that system wherever they get better rights. That's because of social pressure. So, for example, let's take the question of inheritance. Okay? Quite different provisions for inheritance under English civil law and under Muslim law. You can arguably say that a wife under Muslim laws doesn't have such a strong right to inheritance unless the husband makes a hibah, makes a gift or whatever. But if she chooses, now how are we going to understand the nature of her choice if she says, I would like to be governed by Muslim laws? She may be under a great deal of social pressure, and she may find herself under pressure from the sense that you're not a good Muslim woman if you decide that you're going to go for English civil law. So a woman is often faced with the situation of being pressured to take a certain route, a certain legal route, because this is part of her identity, rather than this being part of actually what may give her greater rights or lesser rights.